When you're lost in a world of legal war, you don't know which way to go. There's a hero waiting with expertise to lend. The Utah employment lawyer, HR's best friend. Ooh yeah, he's the advocate of the office.
That song is awesome, isn't it? Man. We're slightly changing our format. I'm going to give our intro and disclaimer here, and then we'll kick off the show with my illustrious father. So here we go. Welcome back to HR's Best Friend, our podcast for HR professionals and business leaders who want to make sure they stay compliant and don't get in trouble and keep their employees happy. D. Scott Crook is the Utah employment lawyer, as the song mentioned. He's consistently listed in Rocky Mountain Super Lawyers and Best Lawyers in America. He is the managing partner of Crook Legal Group. Scott is only licensed to practice law in Utah and Idaho. He is not giving specific legal advice. This shouldn't be construed as legal advice for your problem. If you need specific legal advice, please go to an attorney. Scott is an attorney. We'll leave it at that. All right, let's kick it over to me and my dad for the rest of the episode. Thanks. Welcome back to HR's Best Friend. Dad, how are you?
I'm doing well.
That is good. So today we're going to talk about a current event, and then we're going to answer some Facebook and /Reddit questions that are posted anonymously that are somewhat entertaining and kind of crazy. So it always amazes me that these are real questions, but they are.
Yeah, well, that's when I started practicing. Before I started practicing, I thought, oh, there won't be that much excitement. There won't be that much. The people won't act like they do in court cases, and in fact, people do act like they do in court cases all the time. So it's been entertaining.
Yes. All right. Well, let's start off with the current event. So you've probably heard about this. It's the Kite baby thing, which I had never heard about. Maybe my wife has, but I haven't. The company denied a new mom's request to work remotely while she cared for her premature newborn in the NICU, according to two apology videos made by Kite baby founder Ying Liu. As customers vow to boycott, Kite tells Today.com in a statement that the employee has declined their offer to return to the company. So I saw both of the apology videos. The first one was, very scripted. And then the second one was very panicky after she had dealt with the backlash, because this is a company that makes like a baby sleep sacks,
Right.
which both of my kids have had. I don't think they were Kite baby ones, but so it's just very ironic that for what's reportedly happened here to have happened. So let me read through more of the specifics, and then we can discuss. So,
Okay.
Marissa was an on-site employee for Kite Baby. She worked in the photography studio for a little over 7 months. The maternity policy at the time was that all parents, whether biological or non-biological, who worked for the company for at least 6 months received 2 weeks of paid maternity time. But as part of that agreement, they were required to sign a contract stating that they would return to their job for a minimum of 6 months after the paid leave was complete. Let me just interject and ask you, is that normal? Is that
Well, I don't know if it's normal, but it's not unusual.
okay?
And again, I'm of course answering for Utah, where
Right.
there's no paid leave mandate under statute. This may be different in other states. That might be illegal in some states because some states require paid leave in those circumstances. But in Utah, it's not illegal, and it wouldn't be unusual for if they are giving paid leave for a company to say, okay, well, if we are going to pay you for this leave, you have to agree to, stay employed with us for a period of time after you use the leave.
Okay. Continuing on. So employees who were with the company for over 1 year got 4 weeks of paid maternity time with the same 6 months requirement. So, Kite Baby spokesperson told Today.com that Marissa was offered that standard package, but given her son's situation, was unable to sign the 6-month contract. She did propose a remote option for her job, but given that her role was largely on site at that time, we did not feel that the proposed plan would fulfill the responsibilities of her current position. We told her we understood her situation and informed her that her job would be here if and when she opted to return. Anything to say about that at that point? Should I keep going?
Well, I don't know if you should keep going. I will say this. I'll add this. This is an example of the difference between what is legally required and what is
Smart.
what may be good public relations, right? And so there's going to be a difference between what's legally required here and what may what may have made sense under the circumstances.
Okay. So Marissa, her side of the story, which we get more into here, is said on January 5th, she had a video call with two higher ups where they established her new remote schedule. She says, we set up my entire schedule hour by hour and even set check-in dates going forward. And she said, I was under the impression we were creating a new schedule based on what had already been discussed and approved. So after that call, Marissa had questions about the maternity leave policy, and she was concerned about her eligibility since she had adopted her son. And the version of the policy she saw said that the policy only applied to biological parents. So I guess the question is, can policies do that legally?
Again, in the answer is yes. Depend in Utah,
Right.
because they can make it, since there's no entitlement to any type of paid maternity leave in Utah under any statute. An employer is pretty free to make conditions. Now, I do have to say, in some circumstances, that may, some conditions would be, you can't do an unconstitutional I shouldn't say unconstitutional. If you're a public employer, obviously you can't do an unconstitutional thing. But for private employers, for instance, you couldn't do something that was a violation of Title VII. In other words, only men or only women would be entitled to it rather than men, and that sort of thing. But to the extent that you're talking about a difference between a biological and non-biological parent, there is really no Title VII restriction. And it is a Title VII being discrimination, the anti-discrimination statute. And since there is no statutory requirement that you treat non-biological and biological parents exactly the same for employment purposes, this would be okay.
Okay. But not necessarily good for public relations.
Right, and I don't know that it's necessarily good policy either. With that,
Right.
to make that distinction.
To be fair, so it says, so Marissa asked an HR manager about the maternity leave policy, and she was told that as an adoptive parent, she was eligible.
Right.
The HR manager asked if she wanted to take maternity leave at that moment or wait until her son was home from the hospital. So Marissa said she was going to discuss that with her husband. The remote work option presented to Marissa was pending approval from the CEO, is what a Kite spokesperson said. On January 22nd, the CEO, Ying, did not feel her job could be done remotely, and if she could not return to the office after her maternity leave, then we would part ways. So, following that conversation with the HR manager, Marissa says, I was fired about 8 hours later. I was told, hey, unfortunately, we won't be able to make this arrangement, and for that reason, we will take this as your resignation. Says Marissa, right? And that was with a phone call with higher-ups that didn't include Ying, the CEO. Marissa says she was in tears and said, this isn't what I wanted. She said, I'm not resigning and I'm willing to work. It was never my intention to quit. And she says they were stumbling. They said, we don't want you to think you were doing the wrong thing by choosing your son. So anyway, so that's it. Since then, Kite Baby has offered to give her her job back because of the backlash they're receiving. But that's what happened. Any other thoughts about the Kite baby scandal?
Yeah, so it's funny that we would call it a scandal. I do have to say a few things. Number one, and this is similar to what I said earlier, that there's a difference between what is legally okay and what makes sense as a policy matter or as a public relations matter. And in fairness, and I know that this is probably not won't be a popular opinion. Employers have a lot of things to juggle, and they have other considerations that they have to take into account too. So when they're trying to decide whether to change what would normally be their standard policy for a particular instance or a particular employee, they've got a lot of concerns that they've got to take into account. For instance, what if they had said to her, "Hey, yeah, we're going to permit you to do this, and we're changing our policy for you"? Is there an they have to consider whether that's a good idea, because then later they may have some other employee that they don't accommodate in the same way, they don't change the policy for, and then they might open themselves up unintentionally to a discrimination claim later. And so, yeah, it doesn't seem extremely popular. It probably, it's maybe it wasn't a great idea, but they also probably didn't think that their employee was going to go on, national TV and tell everybody what a terrible place, um, or a terrible consequence or terrible,
Well,
outcome
I
was.
have I have a couple of thoughts. So it's interesting because this didn't really hit the national news until the CEO apologized on TikTok. Like it was really the TikTok video
Well,
that
that's
like
the thing.
apparently I don't know it, but apparently it had gotten out. But then she doing that poured accelerant on whatever fire was already there.
Right.
So that's interesting. My other question though is now that she is like the CEO has come out and said, "Oh, you can have your job back. Please come back. Like you can do what you want." Does that create that same
Yeah.
problem of like, well, now they have to do that for everybody?
Well, no, they don't have to do it for everybody, but they're going to have to consider it, right? Like they're going to have to say, okay, well, now everyone in the world knows that we allowed this. Now if we again decide we can't allow it in this circumstance, is there going to be some issue? And it's not an easy decision to make. I'm sure. Um, I mean, they have legitimate. The employer has legitimate concerns about whether an employee who needs to be on site to do their job can actually be on site to do their job if they're taking care of a child, their child. And I'm not saying that you'd be heartless about things, but at the same time, it sounds like they tried to work it out. There was a decision made that it wouldn't work, and then they said, "Well, we're going to." What I think the problem was, I mean, the clear issue in where everything broke down is for them to come back to her and say, "Oh no, it won't work, so you're fired," without going, "It won't work. Our only alternative is to say that we're going to have to let you go because we can't work this out. Is there another thing we could talk about that potentially might work?" That would probably have been a better um, outcome. But of course, I'm also talking without knowing everything that happened. Maybe that did happen. Maybe what's been reported is incorrect. That they said, "Oh no, it's not going to work, so you're fired," which doesn't sound like a good idea, because they at one point they're trying to be accommodating, and then the next thing they said, "Okay, well, you asked for too much, so we're firing you." That doesn't make a whole lot of sense to me. In other words, they could have said, "Well, our only alternative is to do this. We do need you on site. Um, Perhaps we could talk about some other things." That probably would have been a better way to deal with it.
Okay. Yeah, that makes sense. I think that's interesting. It seems like going public with all of that made things a lot harder for them.
Oh,
If
yeah.
they
I
had,
mean, and honestly, some employers, obviously this had an impact on their business because their business is babies, right? They probably lost business and they had to do this as a matter of saving face.
Right. Well,
But
a lot of people were saying, "I'm taking my, we had you on our baby shower registry, and we're taking you off." Right. So,
right,
assuming those people are telling the truth, then it definitely at least is going to have a short-term impact on their
right,
business. So maybe better policies that are more clearly defined up front probably help. But anyway, now let's answer some Facebook and Reddit questions.
okay.
So here's the first one. These are all submitted by HR professionals, and they're all anonymously submitted. So,
And when you ask or you give me the scenario, it will be clear why.
right. So first, an employee sent out a mass email to new hires that just began last week and upcoming new hires scheduled to begin next week, complaining about the CEO and warning them that they should find another place to work like he is doing. Is this something this employee can be fired for?
And the answer is it depends. And I know that people get that's why lawyers get a bad reputation. They can't give you a straight up yes or no answer. The fact is, you would think that an employee could do that. In a lot of circumstances, an employer could terminate an employee for doing that. And the fact is, in a lot of situations, yeah, you could take disciplinary action against that employee. I, um, but it depends on the type of email that was sent. For instance, the National Labor Relations Act allows concerted activities by employees, right? So, concerted action means if an employee is working hand in hand with other employees to try and improve the conditions of the workplace, and the email was like, "Oh, this place is terrible because you know, our salary is too low. Please join with me in trying to, um, fix that, or else you should probably try and find another job like I am." That probably is a protected um, uh, communication under the National Labor Relations Act. Now, using the company resources to do that, sometimes you can, sometimes you can't, but most of the time that's probably going to be protected. Um, but on other, if if it's just an employee acting by him or herself and is saying things like, "Well, the CEO is fat and he's a jerk, and I don't like him, and so you should try and find another job too," that's probably not going to be protected because that's not concerted activity. It's about your own personal grievance, and it's not really talking about the conditions of the workplace, other than that the CEO is a jerk. So, it depends, and that's something you'd really want to talk to an employment lawyer about before you make any decisions about what to do to that employee.
Wow, it's amazing how complicated that is.
Yeah, I mean, it seems like it would be a slam dunk. Yeah, you can get rid of them, but there's some nuance to it, and you have to be careful.
Interesting. Okay, so there's answer one. All right, here's another one. Posting anonymously due to the nature of the question. I have been asked to terminate one of our employees because we're going to hire the employee's spouse and make it look like she's working here instead of him so that he can keep working here and collect pension benefits. I cannot imagine this is legal, but maybe I'm missing something.
So the answer to that question is, yeah, it's not legal, and it's not legal for a bunch of reasons, but it may not be this for the same reason that you're thinking. But obviously, if an employer wanted to do a contract with somebody to pretend like their spouse was working, and they could probably freely contract to do that. I don't know why you would do that. But the part that makes it illegal is clearly what they're doing is insurance fraud, and they're participating in insurance fraud. Now, they could say, "Well, we're not really doing the fraud, it's the employee who is." Well, you're helping the employee commit fraud by doing that. And that's insurance fraud, and that can get you in a lot of trouble. It's also, you're falsely reporting to the Department of, assuming this is in in America, right? But you'd be falsely reporting income to the IRS, um, knowing that you were being false about it. So, you're filing fraudulent tax returns and tax documents. And also, if, for instance, the Department of Labor were to come in and do an audit and you also reported that that person was working and it was false, that would also be illegal. So that's
Okay.
just a few things.
Well, this person's imagination was correct.
Yeah.
Do not imagine this is legal. It sounds like
Yeah.
she's right.
Yes.
Okay. So, next question. In a recent leadership meeting with HR, it was recommended that when a male hiring manager is conducting a job interview with a female candidate, he should ask a female to sit in on the interview so that the female candidate will feel more comfortable in the interview. What are your thoughts on this? Is this a usual practice?
So I don't know if it's a usual practice, but and my thoughts are about legality and stuff. I don't think it would be illegal to do what was requested, um, and I don't. And in some situations, it actually appears to be a wise practice. But the problem is only because I think it's a wise practice to have more than one person in an interview anyway, whether they're the same sex or a different sex. It really doesn't matter. But maybe it would help a female applicant feel more comfortable if there was a female um, interviewer as well. Um, I think that what they're trying to do is, well, isn't this? I mean, the question really is, the implicit question is this a sexist thing, right? Are you asking, when men come in to do interviews, are you also having a man in the interview? Well, it may probably be sexist, but the question is, does that have any legal consequence? And the answer may be, I mean, I can't imagine that it would be illegally discriminatory to have a woman in an interview um, when a woman is being interviewed. However, it's probably not a great practice to not have two interviewers in an interview anyway, because it just helps against potential liability. Because you can say, well, maybe an applicant heard something or claims that they were asked a question. If you have a witness, it would be helpful. Um,
Okay,
so those are my thoughts.
that makes sense. Okay, so this is my favorite one. This
Okay.
one that I'm about to ask because I think it's so funny, but maybe I shouldn't. Okay. Needing some thoughts. Today was winter solstice, so my company did a lovely Ask a Pagan Yule inclusive thing. It was awesome. A very religious Christian man made a big deal out of leaving the office before we started. He was gone the whole time, no harm, no foul. He then complained to an HR manager. She chose to take everything that was deemed offensive down. She told us that we are HR professionals and should have known that if there is even one complaint, she had to act. Never mind that the executive director had approved everything. Never mind that we are totally decked out for Christmas. Never mind that we had a Hanukkah breakfast. As a side note, the HR manager is flamingly religious. I have a tattoo on my chest that says flamingly religious, actually. As an aside. Thoughts, because all I can think is how discriminatory today was. I'm very curious for your reaction to this.
Well, my reaction to this actual question seems to me to be a reflection of an overreaction in our society to anything religious. The fact is, Title VII protects people from being discriminated against because of their religion, but that does not mean that there's no place for religion in the workplace, right? So it sounds to me like this, whatever the employer was doing, they were trying to be inclusive of everybody, right? So we're having Christmas. We also have a Hanukkah celebration. We also have a pagan holiday. I
Ask a
mean, we
pig.
celebrate pagan stuff. And I'm sure if someone had come in and said, hey, I want to do a Kwanzaa celebration, they probably would have done that. But the fact is, there are I mean, you got to kind of break this down. First of all, does having the celebrations themselves violate Title VII? The answer is probably not. Okay. And the reason why I said, well, I would say not, probably not, almost certainly not. Okay. You can have religious celebrations in a workplace as long as you accommodate people who have religious objections, which sounded like they did with the man who was Christian who left the work site. I mean, it wasn't a mandatory thing, it appears, and therefore him being able to go meant that he was accommodated. Now, if he came in and he complained and said, hey, I don't like the fact that we have pagan stuff up in the office, it's offensive to me. Well, the fact that somebody's got pagan stuff in the office is not a violation of Title VII. Now, it could be a violation of Title VII if it said things like, we're all pagans, let's kill all the Christians. And then objectively, people were threatening to the Christians in the workplace. Well, that would probably be a hostile work environment if it was serious. And so I can't answer 100% that it wouldn't be a violation of Title VII. But if they just have general religious stuff up in the workplace, then that's fine. Now, and so the third question is, well, was the HR person right saying if there's any complaint, we have to take everything down? That's not right. Is that absolutely not right? Because you don't have to have a religious free environment. What you have to have is an environment that is not objectively hostile to one religion or another, right? And
Okay.
so the person saying, well, I just feel so discriminated against. Well, and maybe that person does have a claim, does have a point, because now the person came in and said, well, now we have to take down all the pagan stuff, but we don't have to take down the Christmas stuff, we don't have to take down the Hanukkah stuff. Well, maybe they do, but then the question is, objectively, in doing that, was it a hostile work environment towards all the pagans? I can't imagine there are a ton of pagans, but let's say this one person is a pagan, and that person says, well, yeah, this is actively hostile. I mean, it's all nuance. What would I do if I were giving advice to the employer? I would have it would depend on what the Christian was complaining about, or if he, in fact, was the one that complained about the pagan stuff. I mean, I would give them the same
Well,
advice I gave here.
I've got a solution. In The Office, there's the conflict resolution episode where Angela has a poster of a baby with like a saxophone, and Oscar doesn't like it. So the way that Michael solves that is by turning the poster into a shirt that Oscar wears so that he can't see it, but Angela can. So
Yeah, I forgot about that.
couldn't you just make the Christian guy wear all the pagan stuff so that he can't see it, but the pagans can?
That would be turning something not a violation into a violation. Yes.
I don't
That is,
even know what pagan. I didn't even know you could be a pagan. I didn't know that was a
well,
thing.
well. Anyway, I don't know what religious paraphernalia what there was for the celebration, but in any event, I don't mean to make light of people's religions or anything. But the fact
No.
is, now my answer would be different a little bit if it were a public employer, because a public employer has, they have free exercise and establishment issues that you don't have with the private employer. But
Okay. All right. So last question. So a coworker came to me and said that they were uncomfortable because another coworker has a religious message in their team status. Right? So if you're on Slack or Teams, you can have a little status that's by your name. Right? Sometimes people have fun with those. But anyway, so the coworker also allegedly says, "God bless you" to customers after interactions. We haven't had any customer complaints to my knowledge. My question is, how should we or do we even approach this with the coworker?
You don't. Uh, I think this complies with what I just said. Just because
Right.
somebody is religious, are you going to say to somebody, "Hey, I'm sorry, you can't be religious at work"? Um, Now, there's a distinction. Again, the distinction is this: if the person is, objectively making it a hostile work environment. For instance, if you were to go into anytime you interacted with your coworker, and that coworker then was handing out to you religious tracts and saying, "Hey, if you don't join my church, you're going to burn in hell," and then started not giving that person assignments, and the coworker assignments because they weren't a Christian or whatever. But just because somebody says God bless you, there's going to be some, you know, if you went to an employee and said you can't say God bless you, that would probably be more of a Title VII violation than the fact that the person said God bless you. And in fact,
Especially if they're working at a sneeze factory.
yeah, those sneeze factories. But also in Utah, there's also a specific provision in Utah under its anti-discrimination statute, which says that employees, unless an employer prohibits any discussion of moral or religious or issues in their workplace, they cannot they cannot take employment action against a person for their non-disruptive expression of those religious sentiments. So in Utah, in fact, there's actually a protection that would say, hey, unless everyone can't say, if everyone is prohibited from talking about religion, then you cannot distinguish between what things are said in the workplace, as long as they're non-disruptive to the business, or the business doesn't have a legitimate um, business interest in something else. I mean, in like, for instance, if you're a Republican, the Republican Party, you don't have to allow your employees to have vote Democrat on their on their emails, because that would undermine the purpose of that organization. So
Okay. Well, very good. That is all the time we had for today. We did some good work here. We answered a bunch of questions. Thank you, Dad. We
thank
will
you.
we'll get this out there, and thanks everyone for listening.
Thanks.